1. Definition and nature of partnership. S4. Indian Partnership Act 1932. Partnership is the relation between persons who have agreed to share profits of a business carried on by all or any of them acting for all. Essential elements. Agreement between partners. Business must exist. Sharing of profits. Mutual agency. Each partner acts for all. Example: A, B, and C agree to run a textile business, sharing profits equally. Valid partnership. 2. Formation of partnership created by agreement, oral or written, not by status or law. Minimum 2 partners, maximum 50 partners. Companies Act 2013. No compulsory written agreement, but partnership deed is advisable. Must be for a lawful business. Registration is not compulsory but recommended. Example: A and B orally agree to share profits of their grocery shop. Valid partnership. 3. Test of partnership. Courts apply the following tests to determine existence of partnership. Sharing of profits. Primary test, but not conclusive alone. Mutual agency. Most important test. Each partner must be able to bind others. Joint ownership, not sufficient alone. Common business, all partners must be carrying on the same business. Example: A and B share profits of a shop, but A has no authority to act for B. Not a valid partnership as mutual agency is absent. 4. Partnership and other associations. Feature partnership company QFCO ownership created by agreement registration birth agreement. Law liability unlimited limited unlimited independent agency mutual no mutual agencyKarta. onlyNo agencyMaximum members of the unlimited family members. No limit legal entity. No yes no no. 5. Registration of firm. Registration is not compulsory but highly advisable. Done by submitting application to Registrar of Firms with firm name and address, names and addresses of partners, date of joining of each partner, duration of partnership. 6. Effect of non-registration. An unregistered firm suffers these disabilities. Cannot sue third parties to enforce contractual rights. Cannot sue co-partners to enforce rights. Cannot claim set-off exceeding EU100. However, third parties can sue the unregistered firm. Example: A and B run unregistered firm. C owes them money. They cannot sue C to recover it. 7. Relations of partners. Partners' relations are governed by their partnership deed. If no deed exists, the Act provides default rules. Profits and losses shared equally. No partner entitled to salary unless agreed. Interest on capital not payable unless agreed. Interest on loan payable at 6% per annum. Every partner has right to participate in management. Example: A and B have no deed. A works more than B. Still, both share profits equally by default. 8. Rights and duties of partners. Rights of partners. Right to participate in management. S12. Right to inspect books of accounts. Right to share profits equally, unless agreed otherwise. Right to indemnification for acts done in ordinary course. Right to interest on loans at 6% per annum. Right to prevent new partner admission without consent. Duties of partners. Act in good faith and be honest. Render true accounts to co-partners. Not carry on competing business. Not make secret profits. Indemnify firm for willful neglect or fraud. Act within authority. Example: B, partner, secretly runs a competing business. A can sue B for all profits earned from that business. 9. Property of firm. Firm property includes property originally brought into the firm by partners, property acquired by the firm during its business, goodwill of the firm. Partners cannot use firm property for personal purposes. Property belongs to the firm collectively, not to individual partners. Example: A brings his machinery into the partnership. It now belongs to the firm. I cannot reclaim it personally. 10. Relation of partners to third parties. Every partner is an agent of the firm for acts done in ordinary business. All partners are jointly and severally liable for firm's debts. Partners act within implied authority binds all partners. Firm liable for torts committed by partner in ordinary course of business. Incoming partner not liable for past debts. Retiring partner remains liable for past debts unless creditors agree otherwise. Example: A. Partner takes a loan in firm's name for business. B and C are equally liable for repayment. 11. Implied Authority of Partners. S19. Every partner has implied authority to bind the firm in acts done in ordinary course of business. Buy and sell goods. Receive payments and give receipts. Engage employees. Take loans for business purpose. Acts beyond implied authority require consent of all partners. Submit dispute to arbitration. Open bank account in personal name. Withdraw suit filed by firm. Admit any liability. Example: A partner buys raw materials on credit in firm's name. Firm is bound within implied authority. 12. Kinds of partners. Active working partner. Actively participates in management. Sleeping, dormant partner. Contributes capital but does not participate in management. Still liable for debts. Nominal partner. Lends name to firm. No capital, no profits, but liable to third parties. Partner by estoppel. Represents himself as partner. Liable even if not actually a partner. Partner by holding out. Allows others to represent him as partner. Liable to those who act on that belief. Subpartner. Partner who shares his own profits with an outsider. Example: C allows A and B to use his name as partner. C is a nominal partner, liable to third parties. 13. Minor as partner. S30. A minor cannot become a full partner as he lacks contractual capacity. However, minor can be admitted to benefits of partnership with all partners' consent. Minor shares profits but not losses. Minor's liability is limited to his share in firm. On attaining majority, within 6 months must decide to become full partner or leave. If no decision, deemed to have become full partner. Example: a minor M is admitted to benefits. M shares profits, but if firm incurs loss, M's personal property is not liable. 14. Reconstitution of firm. Firm is reconstituted, continues with changes, when admission of new partner, with all partners' consent, retirement of partner, by agreement, notice, or court order, death of partner, firm reconstitutes if remaining partners agree to continue, insolvency of partner, insolvent partner ceases to be partner, expulsion of partner, by majority, in good faith, as per contract. Example: A, B, C are partners, C retires, A and B continue business, firm is reconstituted, not dissolved. 15. Dissolution of firm. Dissolution by agreement. S40. All partners mutually agree to dissolve. Compulsory dissolution. S41. All partners declared insolvent. Business becomes unlawful. Dissolution on contingency. S42. Expiry of fixed term. Completion of venture. Death or insolvency of partner, if agreed. Dissolution by notice. S43. In partnership at will. Any partner gives written notice. Dissolution by court. S44. Partner becomes insane or permanently incapable. Partner guilty of misconduct. Business running at loss. Just and equitable ground. Example: A. Partner becomes permanently disabled. Court can order dissolution of the firm. 16. Limited liability partnership, LLP. LLP is a hybrid business structure combining features of partnership and company, governed by LLP Act 2008. Key features: separate legal entity, can own property, sue and be sued. Partners have limited liability. Personal assets protected. Minimum 2 partners, no maximum limit. At least 2 designated partners must be individuals. No mutual liability. One partner not liable for another's misconduct. Less compliance burden than a company. Must be registered with Registrar of Companies. Difference from traditional partnership. Feature partnership LLP legal. EntityNoYes liability, unlimited limited R registration, optional mandatory, maximum partners 50 no limit, governed by Partnership Act 1932 LLP Act 2008. Example, A and B form an LLP for their consulting business. If the LLP incurs debts, A and B's personal property is fully protected.